What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all these other citizens who are here today. So when I'm talking, you stop talking. All right. Good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, right. His authorization to do legal work.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm an attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me.
Have a copy of it.
Oh, apparently there's a copy here.
Yeah.
All right. This is in the state of Tennessee, Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because that what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court. regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the State of Tennessee and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Any question? Is that an article 3 trial?
To what?
Will that be an article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly, it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, but unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem with the jury warrants? I'm going to put a notice up there for tonight. If we don't need you tomorrow, but we need you on February the 7th. Is that possible? General, we're going to need to set a trial date in July 10th.
July 15th.
I'm sorry?
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are, in fact, Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
State your names for the record.
Sade Caillou Ashampong.
Osei Ashampong.
Afternoon, Judge. Stuart J. McIntyre happened for patient.
All right. And what are we doing on this case today?
Your Honor, you had scheduled this for just a review to be brought up to date, I imagine, on what
The payment plans, yes. So how is it going?
to date they've paid.
All right. And so how much is left owing on this?
$2,660.12.
So at $500 a month, it's going to be, oh, go ahead.
And I also have like an additional 500 monthly. When we had our case in our final judgment, I believe that was.
What she's saying is we were on the case together. So when we came to court the last time, you had dismissed my garnishment. My wife's garnishment didn't go through, so hers continued. When we put the paperwork in, he made it as another case, so she's still being garnished.
Well, it's $150, so I get paid.
It's additional to the 500 that we had already agreed to. So we're trying to figure out why and if we can stop that garnishment, because we're already splitting a payment of $250 because we're on the same case for $500.
So right now, he gets 500, which was the case that was judgment, and then I pay an additional 150, so a total of
Okay,
650.
so hold on a second, ma'am. You pay that additional 150.
Yep.
How?
$75 is taken out of my check every 2 weeks.
Got it. Mr. Mack, you know anything about that?
Yes, Your Honor, the defendants have actually misstated the facts. There are two judgments, basically, two judgments. So they are equally liable. So Mr. Akumengapong.
Hold on, no. So how?
Because we're on the same case, sir.
Sir, I didn't ask you to state anything to me. So, Mr. Mack, these parties agreed they were going to pay $500 a month.
No, they did not.
Oh, I'm looking at it right now. I'm looking at it on September 1st of 2023. You were present in my court.
Yes.
Defendants to pay $500 per month.
Defendants. Okay. And so what I'm saying is the judgment against Mr. Akumengapong was ordered by you at $500 a month. At the time, there was no garnishment against Mrs. Akumengapong. That's why we sued them both individually and severally.
So hold it. When did the garnishment happen?
The garnishment happened through the Ypsilanti schools. The garnishment was
No, when was that ordered? When did you request a garnishment?
that was ordered signed by this court.
Where's Ann?
Okay, first of all, with all due respect to the court ordered me to prepare an order of garnishment concerning Mr. Akumengapong. And the order clearly states, as of September 15, 2023, and no later than the 15th of the succeeding months, the defendant, Akumengapong, is to tender $500 per month of plaintiff. And then,
All right. No. No. You can play those technicalities all you want with me, but here's the reality of it. The motion and affidavit for installment payment plans was filed in both of these defendants' names. Out of that motion for payment plan, I suspended garnishments because I would have to do that when I order the payment plan. If the order is incorrect, then I'm vacating that order.
I've got both right here.
Both what?
Separate names, separate garnishments. Both right here. Right here.
Show them this. Their motion and affidavit for payment plans. At the top, both names. It is, in fact, once I ordered it, illegal for you to garnish either one of their checks when I've suspended it.
I'm going by what the court has ordered the garnishment. You asked me a question.
Okay. If you're saying, give me that file back. And Mr. Mack, we're going to make it right. Today. All garnishments are hereby ordered suspended. As to both defendants. Defendants, plural, shall pay $500 per month as previously ordered.
Your Honor, there's something else I'd like to bring to the court's attention. Your colleague, Judge Barr, issued an order stating that Mrs. Angamendapong would pay $150 a month. I don't know if that's
Vacated. That's not what was ordered on this case. If you want to bring that up before Judge Barr and he wants to discuss it with me as to which order will hold, you can. But I will tell you in this case that these funds are coming from, it is $500 per month. As I've indicated, any garnishment that has been issued is hereby ordered by this court suspended. Counsel for the plaintiff will prepare that order and have it on my desk by Monday morning. Thank you.
Thank you.
Will the date of the 15th,
Are we finished?
will the date of the 15th that you had ordered and the
Date of the 15th of what? The payments? There'd be a payment 15th of each month, as it's previously ordered, but only $500.
as to both of them combined. So, and I want to get this clear. And there's nothing.
I think I'm very clear.
Well,
These two will pay $500 per month, Mr. Mack. That's it. There'll be no other garnishments of any personal wages or anything along those lines. Those are all suspended. You will prepare an order to that effect, my desk, Monday morning.
all I'm talking about is the mailing of it because of the issue. Okay. So, these folks, they paid $14 to have some kind of expedited mailing, and they keep doing that. But I'm saying, as an officer of the court, and in fairness to them,
Well, what? You now want to be fair to them?
well,
Seriously?
Judge,
He set up an agreement where we could drop something off.
Well-
He told us that we could not drop it off at his office and that he designated a specific place
yes.
and someone else to give it to.
So-
So therefore and it was only once where I did certified mail for on the 15th to be
Yes.
sent to him.
Yes, and they can keep doing that. They can well keep doing that.
It
But-
costs more money to do that. The reason that we said we could drop it off on the 15th
Oh.
is because we don't get it until the 15th.
Yeah.
So we wanted to drop the money orders off as soon as we get them. But he's not allowing us to do that.
Well, it isn't that, it's about dropping it off. But. you
Well,
know,
he
Judge,
instructed us.
No, here's what we're going to do. Your $500 per month, you need to have it in cash. Defendants to pay monthly payments on the 15th of each month into court escrow.
Okay.
So you just bring it here, the $500. I don't know what their problem with taking your money. We'll be more than happy to take your money.
Thank you.
That's fine. All this is done for their convenience, that's fine.
I'm done, Mr. Mack. Have a good weekend.
Thank you, sir.
Same to you.
Court calls case Group 5 Management versus Roderick Smith.